And call the member for Lindsay.
Thank you, Deputy Speaker. I rise today in support of the Intellectual Property Laws Amendment Bill 2014. I am proud to be part of a government that has brought this legislation to the Parliament. Deputy Speaker, these measures enjoy bipartisan support as they are critical to the economic development and growth of our country. And as such, I agree with the statements of the Shadow Parliamentary Secretary for Manufacturing when he said these measures are long overdue. Deputy Speaker, this bill reflects the government's commitment to boosting innovation, growth and development. Strong intellectual property protections are essential in providing security to ideas, inventions and new technology. The cost of research and development is one of risk and reward. To build a smart economy of the 21st century, we must, as a government, encourage creative and entrepreneurial activities. But we must also ensure protections provided to those organisations and individuals that take the ultimate risk in investing their time, their money, in bringing their research to life. This is becoming increasingly important as we must ensure Australia remains competitive on the international stage in search and development of new and emerging industries. Further, we must have enormous benefits for Australian and our local communities by creating long-term and sustainable employment opportunities. The measures I have outlined in this legislation is welcome news to the Australian businesses and particularly in businesses in the electorate of Lindsay that I stand here today representing. But Deputy Speaker, these measures also work very hard to business right across Western Sydney, who I'm sure, like the member for Chifley sitting opposite today, would believe was one of the most innovative and progressive in our country. Deputy Speaker, Lindsay in Western Sydney is one of the fastest growing regions in Australia. As it stands, 2/3 of the Lindsay workforce must commute every single day for employment, 1/3 to the city and 1/3 into Greater Western Sydney. The people of Western Sydney, in particular the people of Lindsay, demand more local jobs. But more than that, they demand smart jobs. Since the days of Macquarie identifying the 5 Macquarie towns, or MacArthur and his sheep, or even Sir Henry Parkes, late of Werrington, long has our part of Western Sydney been innovative and entrepreneurial. The time has come again for the people of Western Sydney to step up into an innovative future. To secure this, the government must provide infrastructure to link our business parks and the protection for our business community to invest. Among those businesses includes one of the oldest plastic manufacturers in Australia, ASP Plastic. A local business in St Mary's, it proudly holds the patents and trademarks to over 200 products. Use of these products range from applications in mining, cabling, construction and, of course, the medical sector. ASP Plastics Managing Director Paul Brennan has welcomed the measures outlined in the amendment. In a letter to my office, Paul writes, "Many of the government's initiatives have merit in reducing the time to raise patents and the associated costs, but we need the legal processes to be faster, more decisive and immediately acting in the interest of the patent holder." Further, Paul highlights the needs for improvements in the intellectual property legislations, particularly in the increasing global economy. I believe this legislation is a good step in addressing these challenges and protecting Australian small medium enterprises like ASP Plastics. We have numerous products that we have designed and patented, and by the time you cover the obvious countries where you see the potential markets, it does not take long to rack up patent fees going into the hundreds of thousands of dollars. This is a very painful exercise for small-medium enterprises, and we have no other choice than to build it into our patent costs into the products that we are designing. And in doing so, we run the risk of making them less competitive. Paul has long feared the costs of protecting his patents in court, and the cost can have a no-win result in legal fees often being more than what the income from those products could possibly be. This has ultimate risks on businesses' bottom lines. Deputy Speaker, I would also like to draw your attention to the University of Western Sydney, a world-class research institution driving innovation across Western Sydney and indeed within my electorate of Lindsay. Barney Glover, the Vice-Chancellor of the university, in regard to the implementation of the TRIPS protocol said, and I quote, "The university is supportive of the amendment's humanitarian dimension, viewing it as a practical response to potential health crises in developing regions. On the bill's extension of jurisdiction into the federal court, UWS sees this as a prudent cost-saving measure. Similarly, the university is of the view that the proposal for a single Tasman patent attorney regime and the document retention repeal both represent a much-needed streamlining of the processes, aligned with the Commonwealth's broader measure to reduce red tape and regulatory impositions." Deputy Speaker, this legislation and its 5 schedules will improve and strengthen the Australian IP system. This delivers on the government's commitment to implement the protocol amending the World Trade Organisation Amendment on trade-related aspects of intellectual property, or TRIPS. Under the TRIPS protocol, Australian pharmaceutical manufacturers will be able to apply to the federal court for a compulsory licence to manufacture generic versions of patent medicines and export these medicines to developing countries in need. Patent holders will be provided with adequate compensation for the use of their patented inventions. In my opinion, this is an opportunity for Australia to provide a humanitarian service to the Third World. Developing countries often have a difficulty manufacturing or accessing patented pharmaceuticals and so are unable to respond to serious health problems. Deputy Speaker, Schedule 3 will make amendments to the Plant Breeders' Rights Act to extend the jurisdiction of the Federal Circuit Court to include plant breeders' rights. Plant varieties are important to the success of the Australian agricultural industry. These rights encourage breeders, many of whom are small business, by providing a sense of safety to the breeder and the farmer alike, ensuring the investment in research and development that will ultimately develop new and improved varieties. At present, the rights owner can only take action against alleged infringements through the federal court, which can be both time-consuming and very costly. The Federal Circuit Court is designed to deal with less complex matters more quickly and informally than the federal court. This bill will amend the Act to give owners the lower-cost option of taking action in the Federal Circuit Court. Deputy Speaker, I today spoke with the former National Rose Society President and Emu Plains resident Glenys Hayne, who said, and I quote, "The amendments to the plant breeders' rights will be most welcome, as they will enable the most amateur breeders a relatively inexpensive way to protect their intellectual property that wasn't previously available to them." Deputy Speaker, this legislation will also help large breeders as well, including Sylvan Australia. Sylvan is the world's largest producer of mushroom spawn, with manufacturing facilities in Londonderry. Sylvan research comprises of 4 basic areas. Firstly, maintaining the genetic stability of established strains. 2, pursuing genetic studies, including breeding of new spawn strains. 3, testing of chemicals, pesticides and fertilisers to bring new specialty products to market. And finally, to explore ways to increase the reliability and efficiency of Sylvan's unique production capabilities. This is a great result for Sylvan. But also in Londonderry, in the northern part of the Lindsay electorate, resides Regal Mushrooms, a wonderful organisation that is producing approximately 20% of Australia's mushroom supply. Put quite simply, Deputy Speaker, this legislation is about protecting local jobs. Deputy Speaker, this legislation cuts significant red tape for local businesses by introducing a single economic market initiative. At present, businesses that want to obtain patents in both Australia and New Zealand have to go through 2 separate application processes. This bill will strengthen our economic relations with New Zealand and reduce costs to businesses by allowing for a single patent application and examination process for Australia and New Zealand. This will increase efficiencies by allowing for a common trans-Tasman regulation of patent attorneys. And finally, the Schedule 5 will make minor technical amendments to existing IP legislation, enabling the government to dispose of unwanted IP documents sooner, saving the government hundreds of thousands of dollars in administrative costs. In all, this bill represents an important package of Australia's improvements to our intellectual property system. It takes into account the challenging global environment, but also makes significant improvements in reducing barriers and protecting the ideas of Australian entrepreneurs and businesses. Further, it delivers on the Coalition's agenda to reduce red tape for those Australian businesses wishing to obtain or enforce their intellectual property rights, and will provide more support for other countries facing health emergencies. I am delighted the government is moving in these areas, and I commend the bill to the House.